नमस्कार फ्रेंड, आप सभी का स्वागत है। फ्रेंड्स, बैंकिंग अपडेट्स में सुप्रीम कोर्ट से एक समाचार। बारोवर शुड बी हर्ड बिफोर क्लासिफाइंग अकाउंट एज फ्रॉडलेंट। रीजन ऑर्डर शुड बी गिवन, सुप्रीम कोर्ट ने कहा है। द सुप्रीम कोर्ट ऑन मंडे held that a decision by a bank classifying a borrower's account as fraudulent must be a reasoned order, and such an order should be passed only after giving the borrowers an opportunity of hearing. State Bank of India and others versus Rajesh Agrawal and others. A bench of Chief Justice of India, D.Y. Chanchun and Justice Hima Kohli upheld an order of the Telangana High Court in this regard. Decision classifying borrower account as fraudulent must be with the reasoned order rule of an ad alteram partem has to be read into it, and hearing is required before borrower accounts are barred. The court held, reading out of the operative part of the judgment. The court said that debarring borrowers from accessing institutional finances causes severe impact on them and is akin to blacklisting with impact credit scores. SC ruling on loan defaulters a setback for banks, say experts. The Supreme Court's ruling on March 27 that said banks must give borrower an opportunity to be heard before classifying their loan account as fraud will result in delay in the loan recovery process, since legal cases are prone to get prolonged, said banking industry experts. Borrowers have the right to be heard before banks classify their accounts as fraud, the Supreme Court ruled on March 27. Earlier in the day, the SC said that borrowers have the right to be heard before banks classify their accounts as fraud, and that principle of natural justice must be followed and read into the Reserve Bank of India 2016 Master Circular on fraud. The court held that when an account is classified as a fraud, it results in civil and criminal consequences of the borrower. It amounts to be blacklisting a borrower from availing any credit. Hence, a hearing must be granted under the Master Direction on Fraud, the country's top court said. In 2016, the RBI issued a circular allowing banks to unilaterally classify accounts of willful defaulter as a fraudulent, a move that was challenged in the several high courts. सुप्रीम कोर्ट के इस रूलिंग से बैंक एक्सपर्ट का कहना है कि जो हमारा रिकवरी प्रोसेस है, जो लीगल रिकवरी प्रोसेस है, इट शुड बी प्रोलॉन्ग्ड, और हमें उन दिक्कतों को सामना करना पड़ेगा क्योंकि हमारे पास रिकवरी के लिए शॉर्ट वक्त होता है, लेकिन हम इस कानूनी प्रक्रिया में पड़ने से ये लंबा हो जाएगा और बैंकर्स को दिक्कतों का सामना करना होगा। थैंक यू फ्रेंड्स, नमस्कार।